Hey everyone, well, Governor Pete Ricketts signed an executive order yesterday that basically puts a moratorium on most evictions throughout Nebraska until June 1st. And I'm going to give you all the details in this video. Hey everyone, my name is Vojchehoske. I'm the director of Randall School of Real Estate. Real quick, do me a favor, support this channel if you would by giving this video a thumbs up. Click that little red subscribe button, hit that little notification bell, and share this video with anyone that you think might benefit from its contents. Okay, I think if you're in the property management industry, you knew this was coming down. The executive order from Governor Pete Ricketts' office finally was signed yesterday that essentially puts on hold most evictions until June 1st. I have a problem with the executive order, though, and that is it was poorly written and it's vague. It failed to put any kind of definition for key terms, and we're going to talk about that more in the video. So let's get into what we do know and what it means for you and I. So essentially, the executive order says that we cannot evict a tenant for non-payment of rent during a period from March 13th through May 31st. Now, the moratorium on evictions, and this is important, falls into one of three buckets. So if the tenant suffered a substantial loss of income resulting from COVID-19 or from some other declared state of emergency throughout the state or a local emergency, and they suffered a job loss, they suffered reduction in hours, or their place of employment is closed down, then they are protected. If the tenant missed any kind of work to care for a relative or a child because that child's school closed down or their daycare closed down, or they have to maintain that 10-person attendance so the child can't attend daycare. The executive order also protects the tenant from eviction if they are confirmed or suspected of having COVID-19 or they're under quarantine, either mandatory or voluntarily because of COVID-19. Essentially, this means you can't evict somebody or use the excuse to evict somebody because of COVID-19. So essentially, it's kind of interesting, actually. Essentially, what's happened is the governor, through the executive order, has created a new temporary protected class under the state fair housing laws. Now, let's talk about documentation, because a key part of the executive order is, yes, the tenant is allowed the protection, but they have to document that they need that protection. So what does that look like? And quite frankly, here's where the executive order really failed, because it provided no definitions of what that documentation is or what it looks like. That puts us at substantial risk as housing providers. So the requirement is the tenant must demonstrate that they need the protection with documentation or other objective evidence. How vague is that? See, that's the problem. And that's a problem for the industry. What kind of documentation can the landlords and managers ask for without violating fair housing or the HIPAA laws? So here's what I'm going to do. This is me. It's not legal advice, so please consult with your attorney, but here's what I'm going to do. As I said, the governor, through his executive order, essentially created a temporary new protected class under fair housing law. So I'm going to treat it as a fair housing issue, or just like I would a fair housing issue. So notification or request from the tenant about their failure to pay the rent, in my non-attorney opinion, is a request for a reasonable accommodation, not unlike a tenant asking for a comfort animal in a no pets policy apartment community. So if the reason the tenant is not paying the rent and they're asking for the eviction moratorium, and it's medically related, it's medical in nature, i.e. something to do with the virus, they're in quarantine, they've been suspected of having it, or whatever the case may be, for me, the objective documentation is a note from a reliable third party. I'm going to use the same process to confirm the need for a comfort animal. That documentation must come from a reliable third party. However, if the tenant is moving forward with the protection because of a financial reason that's outlined in the governor's executive order, for example, they lost their job, I'm going to ask for documentation from their employer. Lastly, if they're claiming protection because they've missed work, because the daycare closed down, the school closed down, or whatever, Probably if I know that they have children, and I'm going to know that because of, or at least I should because of the application, then honestly, I'm not going to ask for any third-party confirmation. But certainly if you wanted to, you could try to get something from the school or the daycare. Again, be very liberal with that. Don't cross any lines because this could put you in fair housing jeopardy. Now, there is one thing else I want to note here. I want to go back to some of the language here. The executive order states that if the tenant misses work to care for a relative or a child, the executive order doesn't define what a relative is. This is important. So in my opinion, it should be broadly interpreted. It could be a cousin, a 10th cousin, a kid, a grandparent, whatever. So I would interpret that very broadly. And again, that's my problem with this executive order. There's no definitions for terms, and we still have to comply. Now, before anybody asks here what a third party or reliable third party is, I'm not going to explain it here. It'd take too long. I would expect anybody that's in this business for any length of time would know at least the basics of what the reliable third-party process is. But I will leave a link down below in the comment section that'll link to a video that will explain what that is. Okay, so there are other things in the executive order that we need to know about. Under the executive order, landlords may still evict somebody for any actions of the tenant that constitutes a clear and present danger. And we use the 5-day clear and present danger notice. Number 2, we can evict a tenant for their actions that we use a 14 30-day notice of default for. And in my opinion, there's nothing in the executive order that says we can't evict a tenant when we've given them proper 30-day notice under a month-to-month lease that it's time to vacate. Again, I do believe that if during that notice period, if they say, hey, I have COVID-19 or I'm under quarantine or I've lost my job, I still think they're probably going to be protected. So if you find yourself in that situation, speak to your attorney. A few other things that are relevant that we have to know about here. Number 1, and in fact, there's about a half a dozen things that I've outlined here. Number 1, tenants are still responsible for paying the rent, folks. Again, tenants are responsible for the rent. It's not a rent abatement executive order. It's an eviction moratorium executive order. So they still have to pay the rent. They don't pay the rent, obviously, then we're going to have to evict them after June 1st. Number 2, what about utilities? So if they can't pay the rent, they may not be able to pay their utilities. What if the utilities are shut off? Now, I think most utilities are not going to do that, but what if? Because I know the question's going to come up. And that is, we use the 14 30-day notice process. So again, that's outside of the scope of the executive order. And in my non-attorney opinion, I think that would be a legitimate evictable process or reason. Number 3, late fees. Can you still assess late fees? And the answer is yes. There's nothing in the executive order that prohibits it. However, use caution here. The best defense against a fair housing complaint is not to get one in the first place. And I do think by going ahead with these late fees and assessing late fees, you may be subjecting yourself to that. Talk to your attorney. Number 4, and it's an interesting one, pet rent. How do we classify pet rent? Is it part of the normal rent or is it separate and distinct? And quite honestly, a lot of it depends on how your lease agreement is structured and how the courts would interpret it. But here's my opinion on this. Do I think technically you could probably evict a non-paying tenant under the guise that the pet rent isn't being paid? Probably, but I don't think I would do that. Talk to your attorney if you want to go down that road. Number 5, let's say, for example, there are 2 adults that are parties to the rental agreement, and they both have incomes. One loses their job, but the other one is fully employed and makes enough money to cover the rent. Can the one still make a claim? Can the one tenant still say, I'm protected? And that's a great question, and the executive order really doesn't address it, but in the executive order, the term tenant was singular in nature. So it is my non-attorney belief that if one of 2 or 3 adults that are party to the lease agreement exercise their protection under the executive order, My opinion is it will cover the entire household. Again, that's my opinion. Talk to your attorney if that issue is relevant to you. Now, last but not least, I encourage each one of you here, if you're a rental property owner or you're a manager, please work with your tenants that are willing to work with you. Develop a repayment plan for those outstanding rents that'll be owed. Spread the rent differential over the remaining terms of the lease. Be proactive here. And one other thing, because I'm hearing this a lot now, I personally don't believe you can require a tenant to extend the current lease agreement in exchange for any kind of concessions that you may come in, that you may negotiate with the tenant to pay the balance that's owed for April and May. I don't believe so, because I'm approaching this from a fair housing perspective. I think that would be punishing the person because they are entitled to because they are a protected class. That's just me, and that's how I'm progressing. I do think that you need to use extreme caution if you're going to go down that road and try to leverage the situation to say, hey, I will extend the balance that you owe over the next 6 or 8 months, but in return, we do want you to sign another 12-month lease. I think that puts you in substantial fair housing jeopardy. Again, that's my opinion. Last but not least, any agreement that you make with your tenant, folks, please make sure that it's in writing. We never do anything that's not in writing. And if you come into an agreement with your tenant and you don't put it in writing and later you get burned, please do not call me and ask me what you should do. Because if you don't put it in writing, you can't enforce anything. All right, that's all I have for this video. I'm sure there's going to be a ton more questions that come up because of this. Please ask them down in the comment section and I'll respond. Until next time, I have 4 requirements of you. Stay safe, stay healthy, stay 6 feet away from me, and most of all, stay sane out there because it's crazy. Until next time.